Good morning, good afternoon, or good evening, depending where you are. Today, we have a truly international audience. More than half of our viewers are outside Canada. From Venezuela, Serbia, the United States, India, Japan, South Africa, Germany, and Mexico. We're delighted to have you here today. My name is Ina Ergasheva, and I'm the Assistant Director at the Canadian International Internet Dispute Resolution Center, or simply CIDRIC. One more abbreviation, important one. CIDRIC is a division of VANIAC, the Vancouver International Arbitration Center, whose name speaks for itself. Question for the audience. What do Armani, Gmail, Shopify, Walmart, Kate Spade, Equifax, and other well-known brands have in common? You're absolutely right. All of them have used our services at some point. For those who are not familiar with CIDRIC, we have been a service provider for the Canadian Internet Registration Authority, or CIRA, since 2002. So we have more than 20 years of experience effectively managing .ca domain name disputes under the CDRP. CIDRIC began administering domain name disputes contested under the UDRP in November 2019, after being approved by the Internet Corporation for Assigned Name and Numbers. Last year alone, CIDRIC handled more than 100 domain name disputes, and in the first and second quarter of this year, the number of new complaints filed with us increased significantly. It is worth mentioning that CIDRIC is the second UDRP provider in the Western Hemisphere and the sixth UDRP provider worldwide. Only one of 6 UDRP providers worldwide. As part of our mandate to promote and deepen understanding of the nuances of domain name disputes, we organize sessions like today. Our panel of experts, whom I will introduce in a moment, will dig beneath the surface of the UDRP and CDRP domain name disputes. Claire will delve into the topic of knowledge and obligation to search. Richard will provide an analysis of a few denied transfer cases, and James will share his thoughts on panel investigation and judicial notice. Our goal is to get the discussion going, so please feel free to ask questions via chat and QA button. And now it is my great pleasure to introduce our panel in alphabetical order, and we will start with Claire Kowarski. Claire leads and co-owns the Swiss-based international IP consulting firm, HSS-IPM, with a roster of clients ranging from major global brands to entrepreneurial startups. Since 2016, she has represented clients in domain name matters, including disputes and high-profile acquisitions under numerous domain name dispute policies around the world, including UK, India, South Africa, Indonesia, and more. Since 2021, she has served as the panelist with the Czech Arbitration Court and more recently with us. As a relatively new panelist, she enjoys robust discussions with domain name experts regarding nuances of the UDRP and is delighted to be here today with Richard and James and our webinar audience. Originally from Australia, Claire is a licensed lawyer in both Australia and Texas. Claire is joining us today from Houston, but will shortly be moving back to Switzerland, where she looks forward to indulging in the usual Swiss cliches of hiking, chocolate, and cheese with her family. Now, our second presenter, James Plotkin. James is bilingual litigation and disputes lawyer in Gowling's Ottawa office, practicing in the advocacy and intellectual property groups. His practice focuses on commercial litigation and arbitration, both international and domestic, intellectual property litigation, as well as administrative law. James has argued before the Supreme Court of Canada, the Federal Court of Appeal, and the Federal Court, as well as all levels of court in Ontario. He also regularly acts in international and domestic arbitrations. He is certified as a qualified arbitrator by the ADR Institute of Canada. In addition to his litigation and arbitration practice, James is involved in domain name dispute resolution both as counsel and adjudicator. James has been published broadly on international and domestic commercial arbitration, copyright, trademarks, and domain name disputes. He co-authored commentaries on the arbitration legislation on both provinces, Ontario and British Columbia. And last but not least, Richard Levy. Richard has practiced intellectual property law in Canada for 40 years. He headed the IP department of 2 law firms in Montreal and was for 7 years general counsel of a hockey and sport equipment and toy company listed on NASDAQ. In 2019, he formed his own firm, Levy IP Law and Dispute Resolutions. He has argued before the Supreme Court of Canada at all levels of Quebec and federal courts, and before the Trademark Opposition Board. With respect to domain name disputes, Richard acts as counsel and adjudicator. As a certified mediator, he has mediated a wide variety of commercial and employment disputes for over 15 years. He is active in EPIC and served as chair of its ADR committee. Richard has written extensively on IP issues and on ADR. Now you know our panel better, and without further ado, I turn the floor over to Claire to delve into the topic of knowledge and obligation to search.
Thank you so much, Ina. It's such a pleasure to be here today. I'm just going to share my screen and jump straight into it. I hope you can all see that. So as Ina mentioned, today I'm talking about knowledge and the obligation to search. I think most of our audience today are familiar with the UDRP, and under paragraph 4B, it sets out a list of 4 circumstances that if any one of them applies, there can be a finding of bad faith. But because it is written in particular without limitation, this means that there can also be a generalized bad faith that can be found. And that would be where you take into account all of the circumstances of the case. What's really interesting is in paragraph 2 of the UDRP, there are representations that are detailed there. And these representations are included in the agreement between the registrant and the registrar when they go to register a domain name. Paragraph 2B says, to your knowledge, the registration of the domain name will not infringe upon or otherwise violate the rights of any third party. And paragraph 2D includes the phrase, it is your responsibility to determine whether your domain name registration infringes or violates someone else's rights. So these were the things that were really interesting to me for the topic today. What is meant by knowledge under 2B? Can knowledge be imputed? And what is meant by your responsibility, and how far does that actually stretch? A good place to start when you are looking at investigating issues under the UDRP is, of course, the WIPO Overview 3.0. But today we wanted to talk about recent trends, and the WIPO 3.0 was published in 2017, which perhaps dates it somewhat. A lot of it is still very, very valid and applicable, but I wanted to look at some more recent cases, and that's what I've done today. It's also, for me, most interesting are the scenarios where there are respondents who don't fit the mold of a classic domain squatter. So we're not talking about cases where there's counterfeit goods. We're not talking about cases where there's a phishing scheme, where there's fraud. I'm much more interested in those cases on the edge where we have a real life respondent, perhaps one that even files a response. I wanted to talk about 2 cases today in some detail, and then I have some information on some other pertinent cases. I should just say that these slides will be shared with everyone after the presentation, so no need to take notes. And then it's very easy to find the cases. You can just Google them. So the first case I wanted to talk about is this folder.com decision, FOLDR.com. This was a case where the respondent was a domainer. He bought and sold domains for a business, and he bought it and then he was offering it for sale for like $80,000, $90,000, so quite a lot. He claimed that he had no knowledge of the complainant, that he had bought the domain because of its meaning. FOLDR, he said, also means FOLDER, folder, like a folder for paper files or when you're folding something. And in this case, the panel did accept that folder, FOLDR, could be treated like the word folder in the English language. But however, in this case, what it really turned on was that the respondent here was a domainer. And he had actually also been involved in prior disputes where he had lost domains. Therefore, the panel found in this case that he was under a very substantial obligation to search, and he took the risk of registering a domain name that could infringe on another person's rights. And as a result, because he took that risk, he registered a domain name which was subject to a prior rights holder's rights with priority. He lost the domain, and it was awarded in favour of the complainant. This next case is one that I actually worked on, that I decided, and it concerned the domain names xcarb.org and xcarb.tech. And this one, the complainant was a very, very large steel manufacturer, probably the largest in the world, and they'd been using the xcarb umbrella brand for their reduced, low and zero carbon products and services since 2020. The respondent had a business in Canada which was related to decarbonisation technologies, but had nothing to do with the xcarb term. He had a separate business that he submitted as evidence. What was really dispositive in this case is that the evidence that was submitted by the complainant of the Google search showed that the results came from, when you looked up xcarb, it all pointed to the complainant. Also, the complainant was using the trademark with the registered trademark symbol or the trademark symbol next to it. So it was very clear from a very, very quick search that this mark was being used by the complainant in relation to decarbonisation technologies and initiatives, and that they were asserting rights in this mark. The respondent here didn't claim that he did not know the complainant. He just said that he was not intending to benefit or take advantage of their trademark rights. Also in this one, carb is more commonly used to describe like carbohydrates, more often carbs, I guess, or as a slang term for carburetor. And the respondent didn't want to use that. He wanted to use it. He didn't want to use the domain names for those purposes, for the dictionary or common terms. He wanted to use it in relation to decarbonisation, which was less commonly used. So the domain name was transferred in that case. I don't have time to go through these in detail, but these are 4 recent cases that are very on point to this issue. In particular, I would encourage you to read the Lambo and the Victron case. In both of those, it was decided in favour of the complainant, but there were quite strong dissents, which expressed a very different viewpoint to the majority. And this brings me to my conclusions on this topic, because we're looking at trends and what we can find. What I found is that looking at the cases, the dissents in 3 panel decisions on this issue show that there can be reasonable minds that differ on this opinion. The majority of cases do tend to favour complainants and put some positive obligations on registrants to search, unless we're really talking about something that's a dictionary term, or the respondent submits as satisfactory evidence showing that there was a good faith purpose and non-targeting. One thing that we discussed in preparing for today was, what role does the respondent profile play? Where you're talking about a sophisticated respondent, or you're talking about a domainer who's been involved in prior disputes, then perhaps they could be held to a higher standard versus an unsophisticated or unrepresented respondent. And this is one of the factors that panelists might consider when they're taking into account all the circumstances of the case. And one thing I found too is that panelists who interpret the UDRP narrowly, they can rail against a generalised targeting standard. And this was really clear in the dissent on the Victron dispute, where the respondent in that case had done some searches of the trademark registers and had found numerous people owned Victron or Victron formative trademarks. And he then said, well, I wasn't targeting the complainant, I just thought this was a good term. And the dissenting panelists tended to agree with the respondent in that case, but he was overruled by the majority. So that's the end of my presentation, but I'd really welcome if there are any questions or any comments on this topic or comments from my co-panelists.
We actually have our first question from
Great.
Paul Keating. In foldr.com, is it your position that the failure to investigate results in bad faith, regardless of the fact that the domain could be used for non-infringing purposes? In other words, is the mere registration of the domain enough to show a violation of paragraph 2 and thus bad faith?
Well, that was what the panel held in that case. You know, clearly he asserted that he had the respondent asserted that he wanted to use it maybe for folding clothes or other purposes. It's a 5-letter domain that you know, we all know that those are attractive domains, but the panelists didn't accept that. They said, no, you know about this and you should have searched more thoroughly. So I think it's arguable.
Yeah, I have a thought on that, actually. So I think it's an interesting question because, there is, freestanding, I suppose, duty to investigate. And again, we can, quibble about how intense that duty is. At the same time, it's not clear to me that failing to do so can necessarily be bad faith, because you can have a situation in which there was no investigation, but the registrant or the respondent has a legitimate interest in the domain. And I mean, maybe other people disagree with me, but to the extent that you could demonstrate a legitimate interest, that kind of means that there isn't bad faith registration. If you have a legitimate reason to register a domain name, then I don't understand how you could simultaneously have a bad faith registration. So I think it might be a little bit more nuanced than that, but that's just my thought.
Okay, Richard, do you want something to add, or we have another question? No? Okay, so we have our second question from Igor Motsneil. Which search, in your opinion, is enough to avoid willful blindness by the respondent? Example, Google search versus TM database. If so, which one? USPTO, EU IPO, etc.
I've got a strong opinion that there's at least a threshold of a Google search, and if you don't do that, you know, everyone can do a Google search. That's not sophisticated. But going to the databases, I think it really depends perhaps a little bit on the profile of the respondent. If they're just a lay person versus if they're, represented and they're from a big company. But I'd be interested to hear what the others think.
Okay.
Yeah, I don't. Yeah, I'm hesitant to say that the panelists should look at the representative or how big the company is and say, well, they should have known, or they should have not only done, what Canada Nuance search, which is a search you need to do to get a company registration, or a Google search, because and then you get into how deep a Google search did you do, how many times did you put in keywords. So, but I see the benefit. I mean, I see the attraction of saying, this person, this representative is so well known, has done so many cases that they should have. One could expect they did a search, and it's really, it's really almost speaks to purposeful negligence or not wanting to, like the monkeys, see no evil. That they didn't do a search. So that's an interesting area, and I haven't seen a case, maybe the other two panelists have, where that mention was made of sophistication of the representative or the size of the company.
For my part, I tend to agree with Claire that, I mean, there should be at least a minimal level of diligence. And I mean, these days, who can't conduct a Google search? I also take Richard's point, though. How many pages do you have to go? Do you have to go to page 10 of the Google search? You have to do that? And then the question becomes, in particular, when you're dealing with a layperson, so, okay, you find something in a Google search, but that doesn't necessarily indicate whether the person has enforceable rights, either registered or at common law or otherwise. And so, I think it's really a case by case, very fact-driven analysis. But I think Claire's point is a good one, which is that there has to be some minimal level of due diligence. Otherwise, you're flirting with, bad faith unless you can kind of rebut that conclusion.
Okay, so now we will turn floor to Richard. You have provided an analysis of a few denied transfer cases which were sent to those who registered. So please, the floor is yours.
So in many and perhaps most instances, when the respondent contests the complaint filed requesting the transfer of his domain name to the complainant, the three-person panel holds for the respondent and denies the transfer. That's my experience. That is because the complainant has the burden of proving three elements. One, confusingly similar. Two, no legitimate interest. Three, the domain name was registered in bad faith. But if one digs beneath the surface, there are more hurdles in the path of the complainant. The first criteria splits into 5 factors. So the 3 criteria are really 7 criteria that the complainant must prove on the balance of probabilities. And here they are. The complainant must prove the domain name is a mark. This is the first hurdle. In the CanadianLinen.ca case, which is in my table, the complainant missed this first hurdle. They were out of the competition after that first hurdle. The words Canadian Linen are only a segment of the registered mark, which was Canadian Linen and Uniform Service. This was a mark widely used for service supplying linens and uniforms to hotels and other businesses. The complainant did not persuade the panel that it had used the 2 words Canadian Linen by themselves as a mark. The respondent was using the domain name to sell linens to consumers and had registered and was using other domain names to provide towel cleaning, which was in competition with the complainant. But the showing of good faith turned out to be unnecessary after that complainant did not, as I said before, pass over the first hurdle. In this case, the complainant tacitly, in my view, and inadvertently admitted, this is not in the panel decision, that the registration was rife, it admitted this. How did it do that? Well, number one, the registration was rife with disclaimers. There was, those were the days when in Canada you had to put in disclaimers if requested to by the examiner. And in this case, obviously, the examiner requested a lot of disclaimers. You had all these generic words. You had linen and hotel, a uniform rather. Number two, the logo on the complainant website is ambiguous as what the real mark used is. It consists, and again, you may want to refer to the table where the mark is reproduced. It consists of 2 lines with a large C surrounding a maple leaf and the large word Canadian in lowercase on the first line. The R trademark marking, it's very small in the reproduction of the logo that's on the table, is placed after Canadian. The second line consists of the words linen and uniform service in uppercase and much smaller fonts. So, I think in this case, the complainant wasn't even sure themselves what to mark as their mark. And it was wiggly. It took 4 years in this.
Here, you lost Richard. Oh, there he is. Sorry, Richard, we thought we'd lost you. You froze there for a second.
Oh, I'm sorry. The mark has been used to, number 2 criteria, the mark has been used to distinguish wares, services, or business. So registration is not sufficient. Number 3 hurdle, complainant had rights in the mark prior to the domain name registration. Number 4, the complainant continues to have such rights. Number 5, the domain name is confusingly similar, so that is, so nearly resembles the mark as to be likely to be mistaken for it. And number 6, the respondent does not have a legitimate interest, which is proving a negative, and which some panelists have commented on. And number 7, the respondent registered the mark in bad faith. So unlike a trademark opposition or dispute in federal or provincial court, there's no weighting of factors. There's no balancing of factors one against the others. You miss one hurdle, you're out of the race. So as you know, the failure of the complainant to prove each of these 7 elements is fatal. So looking at the 4 decisions, these are all .ca decisions I'm discussing. I propose that bad faith is the hinge criteria. The second criteria, no legitimate interest, is itself infused with the element no bad faith. Of the 6 enumerated examples of legitimate interests that are mentioned in paragraph 3.4 of the CDRP policy, 4 of those paragraphs, A, B, C, and D, require good faith on the part of the respondent. Second case that I mentioned today is swimforlife.ca. There, the absence of bad faith was demonstrated by the evidence that the respondent had very little opportunity to hear about, to be exposed to the complainant's mark on her own, and the complainant did not complain about the domain name for 9 years after the respondent began to use it. The respondent gave swim lessons in her swimming pool in Montreal. She translated her business name from the French Nager pour la vie and to get the Swim for Life. There were no features on her website copied from or similar to the complainant's website. The complainant was a regional branch of the Royal Life Saving Society, and they registered and used the term for swim lessons, but only within their own specific region, which was Northern Alberta and the Northwest Territories. So, deciphering this case, I would say that when the mark is suggestive at best and only used by the complainant in a limited region, bad faith is harder to prove. And Swim for Life is one such mark. In the case of Gant.ca and Gantz.ca, the bad faith element was also pivotal. The complainant, an apparel brand based in Sweden, had a prior registered trademark for clothing based on the founder's surname, Gantmacher. But it happens to be the generic word for glove and gloves in French. So the registration, interestingly, did not cover gloves. And the respondent, and it covered many other things beside apparel. There was sunglasses, there was perfumes, and so on. The respondent was in the business of selling domain names consisting of hundreds of generic words in French and English. And he called himself a domainer, which Claire talked about, domainers. He claimed that because he lived in Quebec, he had never heard of the brand Gant. But claims by the complainant that the respondent was selling these domain names for prices in excess of costs were not sufficient to persuade the panel. As a domainer, the respondent had the right to do so. He was not sponging off the reputation of the complainant. Even evidence that an advertisement for Columbia Apparel, a competitor of the complainant Gant, for women's gloves on the respondent website did not itself lead the panel to conclude there was bad faith. How many years between the domain name registration and the filing of this complaint? Okay, everybody's thinking in their own mind. And the answer is 9 years between the interval. And the last case I want to discuss, phonusmobile.ca. The complainant used Phonus, F-O-N-U-S, and the respondent, Phonus Mobile, to sell products related to cellular phones. The complainant sold SIM cards, the respondent did as well. The respondent also applied for registration of Phonus Mobile for cell phone batteries. Although the common law mark of the complainant Phonus is, in my personal view, suggestive of the products, and he only used it for a year and a half before the domain name was registered by the respondent, the bad faith of the respondent was demonstrated to the panel by the fact that the respondent registered the domain name only a day or two after doing business with the complainant. Also, he replicated several elements of the complainant's website on its own website. it would be difficult for a respondent to rebut a claim of bad faith or show it has a legitimate interest when it so closely hitches a ride on the complainant's wagon. In such cases, the panelists sense a whiff of smoke from a recently fired gun. Here, there was only a 1-year interval between the domain name registration and the filing of the complaint. So I think to conclude, it would be an interesting deciphering exercise to correlate the intervals between domain name registrations and complaints. These 4 samples, although only a small part of the pool of complaints that are contested, show that when the interval is large, this corresponds to the denial of a transfer. Any thoughts, Claire, James?
I had just one comment about, I mean, I find this Gantt case is very interesting, but when I read it, I saw that the registrant there he'd registered Gantt and Gantz with an S, hadn't he? Did that support his case further for you? Because the trademark by the Swedish company was just Gant, and you wouldn't say Gantz with an S relating to that. Was that one of the factors you considered?
Well, I guess it was open to us to say, you know, Gant is exactly the trademark of the complainant. Gantz isn't, so we'll require the transfer of Gant, but not Gantz. But
in terms of supporting his claim that it was about gloves, is Gantz, is the S plural in French?
Yes, it is. Yeah. It is. So, and also the domainer had, as I said, hundreds of generic terms, and you know, at least half of them were in French. And but he always registered the singular and the plural of those. So we never either discussed amongst ourselves or in a decision that we would treat the 2 differently.
So we have 2 more questions. One related to the previous topic, and we'll get back to it. But let's start with the second question from Maria Lopez. And this is addressed to Mr. Levy, to Richard. Thank you very much for the excellent material. This is the question for Mr. Levy. Why do you think that the .ca policy, CDRP, was designed for bad faith registration only? Thank you.
Well, I did say that I thought that bad faith was the pivotal element in the complaint, and I did say that when you look at the examples, the enumerated examples of legitimate interest, you know, 4 of the 6 of them require that the complainant, the registrant respondent be in bad faith or have good faith in order to say they have a legitimate interest. You know, I think they really, you know, there's overlap. There's a lot of overlap between the 3 main elements, which are rights in a mark that is confusingly similar, and legitimate interest and bad faith, because you know, it's hard. They're not separate silos, and even though, as I said, legitimate interest has bad faith built into it, they really all sort of reflect off each other. So, you know, I think to say something that was not trite and not that most of the people here are sophisticated people in domain names and trademarks, I thought it would be interesting to say, I think bad faith is the pivotal one, and if you don't think so, then let's hear your arguments. I thought it'd be provocative.
Yeah, you know, I've actually I've thought the same thing. Why is the CIRA policy different from the UDRP in that respect? And I mean, I actually don't know the answer. I would say that as a practical matter, often bad faith registration and bad faith use, there's a bit of a merger of those 2 concepts. In particular, when you think of the more classic instances of cyber squatting, you know, if there's an offer to sell at a disproportionately high price, I think a lot of panels would be ready to infer from that would be bad faith use, but I think would be ready to infer bad faith registration on that basis. And I think a lot of the cases kind of stand for that proposition in the UDRP space. As far as the origins of why there's that discrepancy, I'm not entirely sure. Although I do note, and I hate to put him on the spot, but I noticed in our list of attendees, we have Albert Chang, who's actually counsel to CIRA and probably has forgotten more about the CDRP than most of us will ever know. So he might have the answer. Maybe our questioner should, with my blessing, pester Albert about that, and maybe he might have a great answer for you. But I'm actually not sure why there's that difference.
Okay, so we will, to be discussed, discussion will be continued. Now, let's get back to the question raised by Paul Keating, and it's related to the very first topic presented by Claire. Paul wrote, assuming a search is required, what is the balance there so that there is not a strict liability situation following a failure to search? In other words, isn't it they're more required to show bad faith? So even if registrant did not perform a search, doesn't the complainant need to show that the search would have shown complainant and either A, there is no non-infringing use possible, or B, evidence of actual targeting as opposed to a presumed targeting because of the lack of search? Thoughts? Any?
I'm happy to give my thoughts. You know, this will be one of the factors that will be taken into account is the distinctiveness of the mark. So obviously, if the example that's given in WIPO is orange.com, you know, you can use orange for a lot of different things, but if you're referring to telecommunications services, then clearly there could be some kind of targeting. So the more distinctive the mark, the more far away it goes from a dictionary term, the less likely it's going to fly for the respondent. But it's a very good question, and I've seen panels go both ways. Some panels really see it as a very strict obligation because of that obligation under paragraph 2 that you have to, you know, it's your responsibility that's putting some kind of positive obligation on you. And that was my question too, how far does that go? And I think at a minimum a Google search, and if that reveals in the first responses and on the first page that there is someone that has that mark, then that's more obvious. But if you have to go down to page 20 in the Google search, probably less so. So that's kind of my position.
It would be interesting if I could just butt in here. It would be interesting to I'm thinking of those color marks, you know, the mark for insulation for pink and for UPS and brown and so many other color marks, green for painter's tape and so on. You know, if somebody was able to register green and they didn't use it for painter's tape, well, you know, probably they wouldn't be exposed to transfer request, successful one anyhow. But if somebody used, you know, pink and the website dealt completely with insulation, you know, even if pink wasn't a word mark, but pink was a color mark, it would be interesting to see how a panel would grapple with that. Mm-hmm. If they found out in the search that pink was a color mark.
I was just reflecting on the question and the two kind of conditions that the questioner put forward. I think on the second one, the need to show proof, would there be a need to show proof of actual targeting? I should think not, because if you can show actual targeting, then I think you've more or less made out your bad faith case such that the duty to search wouldn't really arise in the analysis, or certainly wouldn't matter so much in the analysis. And I think the first one, the question disappeared, but I think it was whether they'd have to prove that there's no possible non-infringing, which I take to mean no legitimate interest, like no non-infringing use. I think that puts a little bit too high of a bar on the complainant, in particular, given, as Richard, I think, rightly pointed out, that the legitimate interest prong would require them to prove a negative, which is why ordinarily we require only, quote, some evidence of a lack of legitimate interest, which then lays the burden on the respondent or registrant to prove on a balance of probabilities that there is legitimate interest. So I think that the first condition the questioner put forward is probably too high a bar for the complainant, and the second one I think is redundant, because you can show targeting, again, you've made out your bad faith case.
Mm-hmm. So we received another question, and just this one, and then we will move with presentation by James. This question is for Richard. Regarding the pink example, what if the registrant was a domainer who held it for resale and did not use it per se?
What was the example that you mentioned? I didn't catch the
Pink,
word.
pink.
Oh, pink.
Your pink example.
Oh, my pink example.
Yes.
If the domainer just held it and didn't
For resale, yes.
For resale, yeah. Well, that's what happened in our case of the Gantt case. The domainer originally for a long time held it for resale, and then as he claimed to do for all of his domain names, because he said this is going to be, the Gantt is terrific for somebody who wants to sell a variety of gloves, not one brand of glove. And if you had I don't know, visage.ca for face, and this would be great for people who are selling face creams, but not only one face cream, And he held, and at the time of the complaint, he was still holding a lot of domain names for resale, waiting for the right person to show up who would do it in the way he thought would maximize his return. So I don't see that would have made a difference. It just happened to be in his case that he did use it for gloves.
Okay. Thank you, Richard. And now it's time to hear from James, who will share his thoughts on panel investigation and judicial notice. The floor is yours.
Thanks, Ina, and thanks everybody for being here today. And thanks to Claire and Richard for their very well structured and informative and clearly well thought out presentations. Now you're about to realize why I'm batting cleanup, because they saved the troublemaker for last. The two topics that I thought that would be interesting to address, mainly because I've actually never really heard them addressed in these sorts of webinars, are what Ina called panel investigation, which I think it's a bit of an ambiguous term, but what we mean by that is really the extent to which the panel can fill gaps in either the legal or factual case when a complainant or respondent leaves those gaps for you. The second, if we have time, will be judicial notice, or maybe better called panel notice in this case of facts. In other words, facts that don't require proof because they're so notorious. And so we'll see if we can get to that. But dealing with the first issue, so again, when we talk about panel investigation, we're talking about how involved, how active can the panel or panelist be in, again, filling lacuna or gaps in the case. And I'm again referring to both factual and legal. So from the starting point, both the UDRP and the CDRP require the panel to treat the parties fairly, fair and equal treatment, which is the same language we see incidentally in a lot of arbitration legislation around the world, the trial model law and such. And just for reference, the CDRP, it's Rule 9.1b, and under the UDRP, it's Rule 10b that sets out the equal and fair treatment standards. And so the question is, what does that mean? What is fair and equal treatment? And of course, in particular, when you're talking about UDRP, we're international. So we've got all sorts of different legal traditions, civil law, common law, very local variances of each of them. But in my study of due process and procedural fairness generally, I've come to understand that everybody's got some version of the right to be heard, the right to know the case to meet, and the ability to respond to that case. So, in particular, when it comes to facts, let's say, or actually, let's start with the law, the policy, proving out the elements of the case. So, in civil law jurisdictions, there's a concept, and I hope I don't butcher the Latin. It's Iuria novit curia, which is the court knows the law. And that's basically, as I understand it, in most civil law jurisdictions, allows the court to, or the arbitral tribunal, or I suppose in this case, the panel, to decide a case on the basis of a legal theory or legal reasoning that neither party put forward. In common law jurisdictions, and again, in my experience, and I've looked at some of the case law on this around the world, courts and arbitral tribunals are a little bit more reticent to do that. It seems that both in civil law and common law, investigation of facts is a bit of a no-no, right? Or investigation of the facts without allowing the parties to speak to them certainly is a bit of a no-no, because there's an adversarial process that needs to be respected. And incidentally, the adversarial process, again, which we think is really a sine qua non of common law, inheres in the civil law too, in particular in arbitration. If you look at the French Code of Civil Procedure the Quebec Code of Civil Procedure, the Swiss Code, the adversarial process, la contradictoire, is there as a bedrock principle, even in civil law inquisitorial systems, or ordinarily there's a bit more of an active role on the part of the court. So again, the question is, how deep do you go? If, to put it in context here, if the complainant, say, makes a bad faith argument and they rely on the cookie cutter bad faith examples that you find in the UDRP and the CDRP, and the conduct of the respondent, maybe it's not good, maybe it is bad faith, but it doesn't really necessarily fall within one of those, doesn't neatly fall within one of those. Well, you're the panelist and you're in a bit of a quandary. So, you are disposed to allow the complaint, but at the same time, the complainant has not actually persuaded you with any of the arguments that they've made. So what do? Do you just deny the complaint? Well, sometimes maybe that is what you do if you find that the case is so woefully deficient and they really, phoned it in and didn't do a terribly good job of putting forward a case. One thing that I've done in the past where I was faced with this exact issue is I issued a procedural order asking the complainant to answer a couple of additional questions. And I think reasonable minds can disagree as to whether that's appropriate in one case or another. How much helping should the panel do? In that particular instance, it was actually not a legal point; it was a factual point. I had felt that the evidence that they were providing was really not the best evidence they could have provided, and I had some trouble with it. So I gave them an opportunity to show me better evidence. So I think that that's something that a panel or a panelist can sometimes do to assuage that concern. And again, when it comes to the policy itself, and again, coming back to whether the factors are made out, well, in courts, ordinarily there's the adversarial process, but at the same time, the court generally is seen as having a duty to get the law right, as it were, right? So judges will often, if they think the counsel have missed the mark, again, ask for supplementary submissions or ask questions in the hearing. In these proceedings, we tend to be a little bit more restricted because in, I think, quasi totality of cases, it's all paper-based. So there's no, asking questions in a hearing. And if the parties don't file a second round of submissions, I suppose we could technically ask for them, but that's pretty exceptional. I don't think that generally happens. So you're in a bit of a spot. And again, I think that depending on the legal tradition you come from, how heavy of an onus you feel the complainant should have to meet to make out their case, again, I think there could be reasonable disagreement. In my view, in particular, and I think this is where the identity of the complainant and the respondent, in my opinion, does come into play. If you're dealing with, a big sophisticated party with sophisticated and experienced counsel, I don't think it's unfair to maybe expect a little bit more of them. And maybe it's only incremental. Maybe it's not you're not looking for perfection in the submission, certainly, but if let me give you a real tangible example. So let's say you have a pay-per-click domaining type situation, and some panels will find, pay-per-click is kind of, evidence of bad faith in and of itself, trying to profit off of these names. Other panels, not so much, but it doesn't really matter where you fall on that issue. Certainly, pay-per-click, domaining didn't exist when the UDRP was created, right? So it's difficult to understand how any of the cookie cutter bad faith examples could have contemplated an activity that frankly didn't exist at the time. Now, of course, we all know that the bad faith factors are non-exhaustive. So you can make out an argument that is bad faith, as a kind of a standalone or sui generis version of bad faith. I think that's perfectly fine and open to counsel and for complainants to do. But again, if they don't bother doing that, well, what do? Do you allow the complaint? You say, well, I'm not so sure, especially given that there's no res judicata and there's no prejudice to refiling. I suppose the stakes are lower when it comes to denying a complaint. They could just refile and refine their evidence, subject to, I suppose, arguments of abuse of process or whatever. But yeah, these are things I think panelists often struggle with. Maybe some more than others. Maybe I struggle more than other people. I don't know. But yeah, this is something that I've always found kind of interesting to see how people deal with it. And I'd actually like to hear from Richard and or Claire for their thoughts on this, if any.
Well, I also feel it as you know, as James does, that you know, that the representative, you know, who's used to looking at the boxes and checking off the boxes, should do that as opposed to just flinging the facts at us and saying, okay, you know, the facts I've given you, now you should be able to match these facts against the criteria, the three criteria, again, three criteria in the CDRP, or as I try to make the case that there are actually 7 criteria in the CDRP. So it's frustrating sometimes to say, well, you know, was this a particularly busy day for this person? Because, you know, why didn't they do what, you know, what I train and Claire and James train, you know, new people in the field to do? You know, make sure you've crossed all your T's. So it gets me in a bad mood. I try to prevent it from getting me in such a bad mood that I'm going to turn down the request just for that reason. I haven't done so yet, I don't believe. But it's frustrating, and it bespeaks maybe, you know, of a practice that happens in domain name disputes that doesn't happen in more expensive and drawn out court disputes.
You know, actually, we just got it. Oh, sorry, please, Claire, go ahead. We got an interesting question that I want to take up after your.
Yeah, I just wanted to say that I've had some complaints that I've looked at where the words don't, you know, the arguments are just like a pro forma. They haven't done a really good job with preparing targeted arguments for the facts at issue. But part of the evidence submitted in the annexes, for example, does give me enough to find bad faith under the policy, even though the words don't. But I mean, I'm not going outside of what's submitted. I'm just looking at the annexes. And in that case, as I would find, I think, for the complainant, because the evidence submitted supports a finding of bad faith or not bad faith, whatever. So I think I can sometimes give a little leeway as long as it's somewhere. But I appreciate that there can be, you know, it is frustrating when you get a case that's not properly made out.
No, and Claire, sorry, Claire makes a really important point there. And again, for those who are familiar with Canadian administrative law principles, and you're talking about, you know, the sufficiency of reasons and whether a decision is reasonable, you read the reasons in light of the record, right? The standard is not perfection. I think that same principle can apply to the advocate side, right? If the submissions are not perfect, at least on the, you know, the policy or the quote unquote law, but the evidence is there, I think that goes a long way, as long as what's contained in the complaint lines up with the evidence. So in the example that I gave, the pay-per-click example, if you just rely on the cookie cutter bad faith and you have the evidence of pay-per-click, but it doesn't fall within one of those, I don't think it gets you there. But if you say, you know, they did, you know, this bad faith, this bad faith, this bad faith, they don't really argue it and synthesize the facts to the policy, I would agree a situation like that would not merit denying a complaint as long as the evidence submitted does it. Although, again, I think council's playing with fire if they kind of leave it up to us to piece it all together.
Speaking of bad faith, so we have a question. Can present bad faith use be used to infer bad faith registration?
Yeah, I think we actually kind of addressed that earlier when we were
Yeah, a
talking
little bit
about
earlier. Okay.
the other question about how they kind of merge sometimes.
I see. Should panelists look at the subject website, or would this generally go beyond their role, or do their own Google search?
So, I mean, I can start on this. As far as looking at the subject website, I mean, if the content of the website is relevant and the complainant did not put in timestamp screenshots of the website in their evidence, I mean, I don't know what you're doing. I mean, you need to show us that evidence and not rely on us to go, you know, on a frolic to figure out what's on the website. As far as Google searches, again, like that to me really does go beyond, you know, it's not for us to find evidence for the complainant or the respondent for that matter. Parties need to lead their cases.
Mm-hmm. Another question from Stephen Levy, one of our panelists. We've all seen suboptimal pleadings from both complainants and respondents. As panelists, do you feel that your role is not limited to only deciding the case itself, but extends to making comments, suggestions, footnotes, etc., and playing a larger role in educating the parties, future disputants, other panelists, and others who may read your decisions.
Yeah, I did this recently in a decision. In fact, I did it after consulting James and saying and getting his thought about it, his counsel on it, and saying, what do I do about this? Because as Claire said, there was evidence in the annex, but I kind of had to connect the dots. I felt that way anyhow. And so at the end, I suggested, I hope politely and diplomatically, I suggested that the the representative, the complainant, try a little harder to connect the dots and not leave it to the panelists to do so. And I think that was the basis of contributing to the profession and to the the jurisprudence, because these cases are published.
Since speaking with Richard about that case, I've actually had cause to think about it some more. And where do we as domain name panelists sit within the the spectrum or pantheon of decision makers? So on one end, you have judges who sit in public courts and are there not only for the parties, but also in particular in common law jurisdictions. Anyway, here's my common law bias to develop the law and perform something of a public interest and public policy function, in particular appellate courts, but even first instance courts. On the other end of the spectrum, I think you have commercial arbitrators and arbitral tribunals where the proceedings are private. Arbitration is private by it's necessarily private and often confidential by agreement. And so there, the arbitral tribunals tend to be writing specifically for the parties. No one else is ever going to see it in many cases. So there, I don't think there's really much of a duty to educate at all. We're kind of somewhere in the middle because we're not courts. We don't have orders in council. We're not appointed by parliaments or ministers or whatever. But at the same time, our decisions are publicly recorded in these public registers, and so there is a value to enriching the corpus of decisions so that council and other panelists can benefit from Richard's sage thinking and expression in his decisions to develop the art, as it were. So again, this is a bit of a non-answer. I'm not entirely sure whether it's appropriate to do it in all instances, but certainly in Richard's case, as I understood it, I think that is useful. I mean, if somebody reads that paragraph, they'll think, okay, well, I better do this or not do that. And I think that that's helpful to the bar, as it were, generally.
Any other comments, Claire, Richard?
I just want to say I think that's an excellent question, Stephen, and I did include a comment in that ex-carb decision because there was an unrepresented respondent in that case, and by the submissions, and I say this in the decision, he cited a bunch of cases that were not supportive at all of his position, and I didn't really understand why he cited them. So it felt like he really didn't understand the UDRP very well. So I included a comment to explain a little bit about the decision for the benefit of the respondent in that case, because he was unrepresented.
Mm-hmm.
So we never got to judicial/panel notice of facts, but maybe we'll save that for a future webinar, given that we're running out of time.
Okay, yes, we are running out of time. And dear audience, you've heard our panel contemplated on obligation to search. You've heard analysis of denied cases and on panel investigation. Well, stay tuned in for judicial notice. The discussion is not over, and there are many nuances that don't fit into 60 minutes. So please stay tuned. Follow us on LinkedIn and Twitter, suggest your topics, and we will be back soon with a new session, hopefully in September. Those who are lawyers in BC, please remember to obtain your CPD credits. And thank you to everyone who has tuned in today, and special gratitude to our esteemed panel, and have a wonderful Friday. Thank you very much.
Thanks, everybody.
Goodbye all.
Thank you.
Sure.